Good morning, everyone. I promise I won't sing. I'm Anne-Marie Cotter, and I'm chair of the Law Foundation of Saskatchewan, and I'd like to welcome you all here today. Thank you for coming. This conference is an international conference on human rights law, and I organized it in a way that hopefully it brings together experts in the field of human rights and leaders in their sub-areas of human rights law. So it should prove to be a good and interesting conference today, and I'm glad that you're going to be taking part in it today. Just a brief explanation of how the conference is going to work. There'll be 4 panels. 2 will be before lunch, and then we'll have our keynote speaker, the Honorable Ralph Goodale, and then we'll break for lunch, and then we'll have 2 more panels before the end of the day. The first panel is going to bring together 3 organizations that are experts in the field of human rights law. They've done a lot of work promoting human rights. The second panel will be dealing with very topical and cutting-edge issues of today. One of our speakers will be dealing with race relations in the United States, and we've heard so much about that lately. And then the other speaker will be coming to us from Ireland, because he did want to come in person, but he has a big case over there, so we're lucky to have him. And he'll be speaking on refugee law issues from the European perspective, because as we have seen in the news, Europe has been really in the forefront and the first landing for many people. So then we will go on for panel number 3 in the afternoon. I'm sorry, that was panel number 3. Panel 2 I will be part of, and that will touch on disability law issues. And I will have my former colleague, Sonia Kerr, discuss special education law in the United States, touching on children's rights issues. And then I will discuss disability law from the employment law perspective of people who cannot work due to a mental or a physical disability, and they needing assistance from the Social Security Administration. And then our last panel for the day will have 2 experts dealing with sustainability and global governance issues as they relate to human rights. So sit back and relax, and I hope you enjoy the day. We'll begin with our first panel, and I'll introduce them. Our first speaker comes from Geneva, and he is in Geneva to present at the United Nations. So we are happy that he could take the time out to be with us today. He is Alex Neve. He is Secretary General of Amnesty International Canada, and he has a wealth of information on the human rights area that he will discuss with us today. And he's going to be reviewing the challenges and opportunities that lay before us in the area of human rights as they relate to Canada and globally. Our second speaker will be Marvin Bernstein. He's Chief Policy Advisor with UNICEF Canada. And he has done a lot of work to promote child's rights in the area of human rights. And he will be discussing the humanitarian issues that go along with child's rights in the world today. And then our final speaker for that panel is Anderson Joyce, coming to us from CUSO International. And he has a wealth of information, having been an attorney or lawyer for over 30 years. And he decided in his retirement to give back to society further and join CUSO International, having several tours in developing countries, and most notably Myanmar, that he will discuss with us today, the issues that present over there. So I welcome them to the panel today, and if they could come up and join us. Thank you.
Can you hear us, Alex?
Loud and clear.
Can everyone hear Alex okay? You can get started whenever you want.
Over to me. All right. Well, thank you very much. I certainly regret not being able to join you in person for today's conference, and I did give it my best shot, but things didn't wrap up here in Geneva until late in the day yesterday, and I simply couldn't figure out a way to get from Geneva to Saskatoon in time. But it's wonderful that technology gives us this link instead. And that said, I think it's important and significant to be here in Geneva this week. You'll hear about that in a moment. And I think it helps shape the remarks that I want to share with you. So it's all good. As Anne-Marie noted, I've set out my remarks in general around the theme of taking account of the recent election and what that means now for Canada and human rights. And it's certainly a question very much in the air in Geneva this week. Let me tell you why. Many of you will know that Canada is a party to numerous international human rights treaties, and that includes the International Covenant on Economic, Social, and Cultural Rights, which is really, in a sense, one of the two pillar treaties in the international human rights system. And as such, that treaty's expert body, known as the Committee on Economic, Social, and Cultural Rights, periodically holds Canada to account. And that certainly includes by carrying out a review of Canada's record of compliance with the Covenant's important provisions. And these are provisions that deal with such essential rights as healthcare and education and housing and food and safe water. And it carries out those reviews from time to time. Well, Canada ratified the Covenant back in 1976. Makes me realize that now 2016, I guess, is the 40th silver anniversary year for our ratification. And over those 4 decades, the committee has scrutinized Canada several times. But this is the first review since 2006, so it's been a while. But perhaps more significantly, this is the first review of Canada by any UN human rights body since the change of government. So you can imagine there's a fair bit of buzz and anticipation as a result. I can't count the number of times this week that committee members and representatives from the large Canadian and provincial government delegation, and certainly civil society and Indigenous activists like myself who have been here, use the terms new government, new opening, new beginnings, new opportunity. And that's inevitable with any change of government. It always means new priorities, a new approach, a new agenda. But this new government has truly given rise to an expectation of what I would call substantial change, transformational change. And let's be clear, one area where that kind of change, transformational change, is sorely needed is the human rights front. And I say that because there's no way to mince words here. The past decade was deeply troubling. I've often, and others have often said, debilitating when it comes to Canada and human rights, both in terms of our domestic and global standing. And I want to start with 2 very short anecdotes, therefore, that give quick personal glimpses of the evolution of Canada's global standing in recent years. I'm not going to take much time with this, but I think they're helpful, quick little glimpses that perhaps most importantly set us up for where we need to head next. The first is in 2010, so about 6 years ago, and that year I made 3 trips to Guantanamo Bay, and that was to observe the trial against Omar Cotter. The Canadian citizen, of course, who had been taken into U.S. custody on the battlefield in Afghanistan in 2002, only 15 years old, held at the notorious Guantanamo prison camp between 2002 and 2012. And his case, of course, gave rise to all of the serious human rights concerns associated with Guantanamo Bay: detention without charge, unfair trials, torture, and ill treatment. And in his case, the refusal to acknowledge that he had been a 15-year-old child soldier when he was captured. Equally troubling, of course, was the defiant refusal of the Canadian government to acknowledge the violations, to press for the abuses to end, and to truly go to bat for the rights of a Canadian citizen. Well, I always remember the reaction of one Marine assigned to be the NGO minder. We always had a minder on one of those trips. When he heard I was Canadian, and clearly referring to the well-known indifference of the Canadian government to Omar's plight, he said to me, "What is it with you guys anyway? I thought you were the human rights good guys." Well, hold on to those words for a moment. The other example is an encounter with a European ambassador at an event in Ottawa not long before last year's federal election. And we were making polite conversation at a reception, and he became quite frank with me about his views about Canada and human rights, particularly thinking about at the world level. It came up, I think he was hoping that I was somehow going to be able to make sense of it all for him. But he had a great line that he used to describe his own point of view. He said that as far as he was concerned, when it came to Canada and human rights, we were sometimes a champion, we were often an obstacle, we were most frequently a puzzle, and we were never predictably a partner. Well, I'm going to suggest to you that those two brief interludes frame our task and give us a sense of what we're looking for during this time of change in Canada. Human rights good guy, always a champion, never an obstacle, consistently clear, and always a reliable partner. And for change that fundamental and that transformative, it really has to start with some essential core values and principles aimed at advancing a strong human rights agenda. Values and principles that will ensure that human rights set the tone for government, that they set the direction for governance, and on a day-to-day basis are at the very heart of governing. So let me suggest to you 6 such fundamental principles. First, and very obviously, it begins and ends, I would suggest, with unwavering respect for the universality of human rights. And the most important word there actually is, let's put rights aside for a minute, the word I want you to focus on is universality. And universality means many things. Let's unpack it. It certainly means all rights. And that means that we show the same regard, for instance, for the ban on torture as the obligation to provide essential health care. The same concern for free expression as for adequate housing, for fair trials, and an adequate livelihood, unlawful detention, and quality education. You get my point. The key factor here is that human rights do not speak only to what governments cannot do, but also what they must do in order to uphold human dignity and integrity. Well, sadly, we did not yet hear a true shift on this front from Canada in Geneva this week. Instead, we heard variations of old refrains that economic, social, and cultural rights are different rights and certainly aren't in need of or suitable for remedies in the same way that, for instance, civil and political rights are. Universal also means all countries, so that we speak out whether a country is a close trading partner or a military ally, an irritant or an implacable foe. And that means whether it is North Korea, which of course is always easy to criticize and deserving of such. It means Saudi Arabia, tempting to criticize, but always overtaken by concern about oil deals and, let's say, maybe arms sales. Mexico, certainly in need of criticism given the crisis of torture and disappearances the country faces, but close friend, trading partner, tourist destination, so maybe not. Well, that has to change if we're really going to commit to universality. Universal certainly means at all times, whether a country is calm and stable or facing insecurity and turmoil. And that, of course, takes us to the heart of the ongoing false debate that somehow we have to choose between security and human rights rather than embrace the fact that national security is actually entirely dependent on strong human rights protection. And I guess you're going to have a chance to hear from Minister Goodale and hopefully push and prod him a bit on that later today. Universal requires us to be consistent in upholding at home the standards of human rights protection we promote abroad. And that's, of course, the age-old adage of walking the talk. And that's why the review in Geneva this week is important. It gives us a chance to demonstrate to other governments that we will take our own international obligations as seriously as we press other governments to do similarly. Universal certainly means for everyone, rejecting double standards and discrimination that permit human rights violations against some individuals and communities that we would never tolerate for others. And in Canada, most certainly the top of that list is Indigenous peoples and a range of concerns, including access to safe water for First Nations, violence against Indigenous women, concerns around consultations and consent, underfunding of First Nations education, and all of those, I can assure you, have been in the spotlight in Geneva. Second value. Respect for women's human rights must become the very essence of Canada's global and national human rights identity. Canada is a country so very capable of demonstrating leadership with respect to gender equality and women's human rights in both words and in action. And we've had some good steps forward here, haven't we? I mean, our Prime Minister's embrace of feminism is remarkable. Gender parity in our federal cabinet has been noted around the world. But this must go deeper, wider, and of course, importantly, it has to be sustained. That means many things, but for instance, let's look at some of what's already underway. The admirable global initiatives launched in recent years by Canada under the previous government, dealing with such serious concerns as maternal and newborn health or the widespread practice of forced early child marriage. Those need to continue, but they need now to be rooted in a framework that is focused on women's equality with a human rights perspective at the very core, and that includes sexual and reproductive rights. That's not been the approach to date, where very often we've seen programming that has talked more about saving women and girls than about empowering them. On the home front, the quick decision to launch the Murdered and Missing Indigenous Women's Inquiry is a good sign, a long overdue development. We now await word, hopefully, that the inquiry will truly be a national one. Do pay attention to this because it's crucial in the coming weeks. It needs to be national, involving all levels of government and not only focused at the federal level. A third value, it's most certainly time for a new collaborative relationship with Indigenous peoples, grounded in full recognition of and respect for their inherent rights. This too is off to a promising start. We've had a lot of fine words, big ideas, an emotional prime minister, a dramatically different tone, and of course, talk of this promising idea of a nation-to-nation relationship. All very good, of course it is. The calls to action from the Truth and Reconciliation Commission have been embraced. They await attention. Late last month, after almost a decade of contentious litigation, fought vigorously, I would have to say. We were part of the case, I know it, at every turn. A historic Canadian Human Rights Tribunal ruling came down finding that First Nations children have endured decades of deep discrimination on reserves across the country. Well, the fact that there will be no government appeal of that groundbreaking rights regarding decision was such a refreshing, significant shift. That's step one, of course. We now actually need to see action to live up to the ruling, but it is incredibly important to note that it's no longer being fought. But how far past the new tone and fine words will we go, I think, is the really crucial question here. Let's think about land and resource claims and disagreements. They linger in so many corners of the country, and far too often the views of Indigenous communities have been disregarded as decisions about pipelines and mines and oil and forestry have sped ahead. That is where we will see the true test of a new relationship. And human rights points the way here. Many of you will know that 9 years ago, the United Nations adopted the landmark Declaration on the Rights of Indigenous Peoples. It had been opposed for several years and then reluctantly acknowledged, but at the same time still continuously sidelined by the previous government. We must truly commit to it and embrace it now. And the government says that they will. And that's important. It points the way ahead for resetting this fundamental relationship, and as many have noted, is really the roadmap for reconciliation. It came up frequently during the review this week in Geneva, and The government was pressed frequently to give details, timeline, to give some sense as to how this is going to go ahead, and we weren't there yet, and we need to get there. We need this to become more concrete. And I think we also need to remember that it's something that is a challenge, an imperative for all of us. This isn't just for Indigenous leaders and communities, and it's not just for those who we vote into office to figure out. It's about all of us, because this nation-to-nation relationship really, truly does draw us all in. The next value I want to highlight is that our new approach to upholding international human rights must be rooted in a strong commitment to global cooperation and multilateralism, to the international mechanisms and standards that are meant to ensure human rights protection. In recent years, too often, Canada has been dismissive and even derisive of UN human rights processes, too quick to complain about the UN from the sidelines. Well, the UN, with all its imperfections, and they are many, is nonetheless where the world comes together. It's how the world comes together. It's the only place the entire world comes together to deal with human rights. We have to be engaged. And there's lots of openings. This week's review offered one such opportunity, and I think it was a missed opportunity, sadly, in some ways. But Geneva will be in the spotlight again next week when Foreign Minister Stéphane Dion is going to make a speech at the UN Human Rights Council on Tuesday. The first such Geneva speech by a Canadian minister in 5 years. And it's really a tremendous chance to lay out a clear vision for Canada and human rights. So let's all stay tuned and watch that. There certainly are lots of job openings within the global human rights leaders field at present. The Syrian refugee crisis is clearly lacking an international champion. Rather, there is bickering, there's incoherence, there's confusion.
Alex, can you hear me? We lost you for a second. Just give us 1 second. Can you check your mic?
Can you hear me?
Yep, we're good.
Oh, okay. Did you hear me talk about Syrian refugees? Yeah?
Just start over there on the Syrian refugees, I think.
Okay.
Thanks.
Well, I was just noting that the Syrian refugee crisis is clearly lacking an international champion. And what we see instead is bickering and incoherence and confusion, particularly in Europe, with many states sitting to the side and doing little, including wealthy Gulf states. And of course, we've come so far as Canada, as a nation, and importantly in communities, Saskatchewan and communities right across the country, with our tremendous effort to respond to what is, of course, the gravest refugee crisis the world has known since World War II. Well, we can take that example to the world stage and push and lead a generous global rights regarding Syrian refugee plan, and we really should do so. Fifth, we need to rediscover Canada's peacemaking and peacekeeping roots. When faced with international crises and conflicts, of which there have been so many in recent years, Syria, Ukraine, South Sudan, Libya, northern Iraq, Yemen, the Central African Republic, we are the country that must push for human rights to be put first in the global response. That has to be our role. That's not to say that there is or is not a military role at times, or that Canada should or should not take up some of that military role. But it really cannot and should not be our starting point. It's not our greatest strength. It's not our most remarkable expertise. Our contributions really do lie elsewhere and need to be revived and strengthened, and I think once again celebrated. I think we see some signs in that direction in the recently announced Iraq-Syria strategy. But it's only a glimmer there, and I really think this is something that needs much more deliberate attention. And it certainly includes things like rediscovering and reclaiming our once upon a time, I think I'd use the word passion, for such important global innovations as the International Criminal Court and the groundbreaking, but generally disregarded more recently, responsibility to protect principle. And finally, my last value that I want to highlight is the following. Embrace dissent. Welcome critique, engage with opposition, ensure there is unhindered space for advocacy, robust advocacy on public policy issues. And you know, I have to say, in many respects, it's particularly disheartening that that's something I need to put prominently on this list. And how could it be, how did it come to be in Canada that that's on our list? But it is of urgent importance because over the past several years, various government measures have punished and sought to silence or muzzle those who disagree and differ with government, much of which was deeply ideologically rooted and motivated. That included hot-button issues such as the rights of Palestinians, women's equality, the toxic combination of Indigenous peoples, the environment and pipelines, and more. But the clampdown and the resulting chill fell on many shoulders. Civil society groups, watchdogs, human rights activists, women's equality researchers, environmentalists, scientists, academics, and others. And that's all of very deep concern from a human rights perspective. Essential freedoms, obviously. Freedoms to expression, opinion, access to information are at stake. But it also cuts to the heart of our democracy and really impoverishes us as a society. Well, that crackdown must end, and instead a new commitment to opening up that space for debate and disagreement must prevail, in which we take particular care to ensure that voices from more marginalized and disenfranchised communities are heard. The government has signaled its intention to turn this around, and that is good. But this is something we must all take to heart because it was ominous to see how quickly and readily those freedoms and the space for public dissent began to disintegrate in recent years. And if there's one thing we must take from that, it is that we can never be complacent and must remain ever vigilant. So there's a range of values and principles that I offer as a set of guidelines for how we can reignite and reimagine a strong Canada when it comes to human rights, and they range considerably. Some are very overarching and aspirational, such as the talk of universality of human rights. Some have focused in on some specific initiatives, like Indigenous women and Syrian refugees. But I guess I would leave you with this. I'm confident. I can't see you, I can't sense the energy in the room, but I'm confident that you're a group that has come together because you know what a human rights vision for Canada entails. You know the urgency, you know the value, but I think I'm absolutely clear that you also know the immense possibility of Canada truly being a land of human rights, and that you also know that it is us, nobody but us, who in the end can make it so, must make it so, and I truly, truly believe shall make it so. Thank you very much.
Thank you very much, Alex. We have time for a question or two if somebody would like to ask something of Alex today before he leaves us. All right, well, thank you so much, Alex, for being here today and giving us your point of view on international human rights today. Thank you.
Okay, well, I hope the rest of the day goes well. Thank you.
Great, thank you. All right, well, we'll welcome to the stage now Marvin Bernstein and Anderson Joyce.
Yes. Okay, well, I'm going to go first. I'd like to thank the organizers for inviting me back to my adopted province, my adopted city of Saskatoon. It's absolutely wonderful to see so many friendly faces in the audience. I'm really appreciative of an old picture finding its way into the program. That was the day I was appointed and sworn in as the Children's Advocate. So it goes back 10 years, more hair, less gray, but it's all good. So just in terms of talking about the role of UNICEF Canada in a domestic context. For those of you who are unfamiliar with that role, we work with all levels of government in Canada and with other partners to promote the rights of children everywhere in this country, and to advocate for the implementation of the Convention on the Rights of the Child, the principles, the ethical standards that are set out in that international human rights document. And given that this is an international human rights conference, so pleased that the college is addressing this topic today. It's important to recognize that the convention, which was adopted by the UN General Assembly on November 20th, 1989, is the first international human rights instrument to articulate the entire complement of rights relevant to children. So economic, social, cultural, civil, and political. It's also the first international instrument to explicitly recognize children as social actors and active holders of their own rights. Its importance was clearly seen from the outset, as it became the most rapidly and widely ratified human rights treaty in history. The convention has now been ratified by 196 nations, with the United States holding the dubious distinction as the lone abstainer. This almost universal ratification reflects an unparalleled level of agreement among the world's nations. Now, on December 13th, 1991, almost 25 years ago, Canada made a set of commitments to children when it ratified the convention. So remember that date, December 13th, 2016. We're celebrating the 25th anniversary of Canada's ratification. So the promise was to do everything in our power to promote and protect the rights of our youngest citizens. This commitment was made not only to some children, but to all children. It was not only to advance some of their rights, but all of their rights, including their right to survive and to thrive, to grow and to learn, to have their voices heard and taken seriously, and to be protected from discrimination and violence in all of its manifestations. So how have we done? So I'm going to deal with three principal topics. One is, what is the current state of Canada's children? Secondly, what are a few of the current challenges facing us in Canada that are impeding the implementation of the Convention? And lastly, what are some of the steps that we can take in Canada to improve the current state of Canada's children and fulfill the original vision of the Convention? So in terms of the current state of Canada's children, well, when I returned to Toronto for my tenure as Children's Advocate in Saskatchewan more than 5 years ago to take up the role of Chief Policy Advisor at UNICEF Canada, I expected to find some challenges in promoting the implementation of the Convention on the Rights of the Child. However, I must say that I was surprised and disappointed to find that on the international stage, and we heard Alex's first presentation, that Canada's reputation was fading, and that we were stuck in mediocrity in terms of the overall state of the well-being of our children. This is particularly noteworthy since internationally, Canada was among the founders of the United Nations and has a long history of support for human rights. It's been continuously engaged with every human rights declaration, covenant, and convention that has been negotiated under the authority of the United Nations since the end of the Second World War. Canada played a significant role in drafting the UN Convention on the Rights of the Child between 1979 and 1989, and in the optional protocols related to child exploitation and to children in the armed forces, child soldiers. So I want to now spend the next few minutes discussing UNICEF's report card 11, prepared by UNICEF's research arm, the Innocenti Research Center in Florence, Italy. In particular, there is a league table of child well-being ranking 29 affluent nations on an average of 26 indicators across 5 dimensions. They are material well-being, health and safety, education, behavior and risks, and lastly, housing and environment. So in this 2013 comparative study of child well-being in the world's richest countries, you may be surprised to learn that Canada ranked 17th out of 29 nations measured, a middle position that hasn't really budged since we last measured it over a decade ago. Both Report Card 11 and the Canadian Companion, which we prepared at UNICEF Canada and have called Stuck in the Middle, can be found on our website. Interestingly enough, but perhaps not surprising, the top 5 performers are all Nordic countries, and ranked in descending order, they are the Netherlands, Norway, Iceland, Finland, and Sweden. So maybe we should all go to Scandinavia and pick up a few hints. In contrast, the bottom 5 performers, again in descending order, are Greece, the United States, Lithuania, Latvia, and Romania. Areas where Canadian children are doing better than their peers in most other countries include the low smoking rate, where Canada came in 3rd of 29 nations, and the high achievement of children aged 15 and under in math, reading, and science, 2nd out of 29 countries. So our education system does a comparatively good job in the early years in equipping our children with functional skills, but not necessarily when it comes to developing healthy social and family relationships. And there appears to be slippage as these students progress through the educational process. We know that Canada has made some progress on a number of other fronts. Breastfeeding rates are increasing and need to advance further. We have demonstrated some commitment to improve the mental health of children and adults, but more needs to be achieved. There are considerable advances in federal and provincial legislation that better protect children from injury and exploitation, but oftentimes that is on the criminal justice side. It's in terms of more punitive sanctions rather than focusing on prevention and education. But in some fundamental aspects of survival and health, the state of our children is alarming. The health of Canada's children is a bellwether of the state of their rights. Canada has the technology, the information, and the resources to ensure the highest possible state of health for its children. Yet in the domain of health and safety, Canada ranks as low as 27th of the 29 industrialized countries measured. Among the greatest areas of concern, just to kind of enumerate some of these, include the high rate of unhealthy weight or obesity, where we came in 27th of 29 countries. The high rate of bullying, and we know that this is a serious problem across the country, 21st of 29 countries. The high rate of relative child poverty in this country, 21st out of 29 industrialized countries. The lower rate of children aged 15 to 19 participating in further education, 24th of 29. The low rate of immunization, 28th of 29. And the high rate of cannabis use, 29th of 29, right at the bottom. Disappointingly, Canada's children are among the unhappiest, and we dropped 7 spots to a ranking of 24th of 29 countries when children's views of their own life satisfaction are measured. So when taking into account their views of their relationships with their peers, their mothers and fathers. So this reinforces the value of speaking to young people and not just trying to use other measures to to evaluate their well-being. They may see things very differently. The troubling indicators for healthy relationships in the report card suggest that we need to pay more attention to the development of healthy relationships at home and with peers, including the role of social media and families squeezed for time. The effect on well-being of a child's closest relationships is difficult to measure, but emerging evidence suggests that the quality of parent-child trust and communication has a greater influence on children's emotional health, school engagement, and risk-taking behavior than family affluence. So in factoring in the size and health of Canada's economy, among the 29 nations measured, UNICEF's Report Card 11 clearly shows that the overall well-being of Canadian children could be much better. Other countries, for example, have invested more robustly in children's well-being and improved their ranking on the league table. In this regard, it's critically important to remember that the state of our children's well-being isn't predetermined. It's not inevitable. It can be positively affected by progressive and inclusive policy development that is respectful of children's convention rights and supportive of building strong families and communities. So the second area that I want to address is, so what are a few of the current challenges facing us in Canada that are impeding implementation? The first, and again, to kind of extend the theme from the first presentation, a lack of political will and the failure to adopt a comprehensive and coordinated approach to children's rights as a political priority. What has been missing is the political will to implement the convention in both spirit and intent within federal, provincial, and territorial governments, at the municipal level, and in the corporate and voluntary sectors. A second challenge, a failure to sustain a culture of respect for children's rights. One of the unique challenges in Canada is that we are a vast country, geographically, and are positioned in a continent where our neighbor to the south hasn't yet ratified the Convention on the Rights of the Child. This is very different than the culture in Europe, where there is a greater awareness and enthusiasm for children's rights in the minds of academics, professionals, the general populace, and children themselves. I've seen this myself since traveling to Geneva, traveling to Europe, attending other human rights conferences. The reception is very different than what you find here in Canada. That's why kudos go out to the College of Law in terms of convening this kind of session today. Another obstacle, the problem of federalism, our constitutional structure. That is to say, some areas affecting children fall under federal jurisdiction, while other matters affecting children fall under provincial and territorial jurisdiction. This can lead to a fragmentation in governmental policymaking and to a passing of the buck mindset, with the rights and well-being of children falling between the jurisdictional cracks. A fourth obstacle, a failure to treat Indigenous children fairly and equitably, and a reversion to entrenched positions and polarizing litigation, instead of taking a more purposeful and conciliatory approach to resolving long-standing areas of systemic disadvantage. So, as Alex was saying, we certainly are optimistic and hopeful that with the change in government, the spirit and the relationship with First Nations and other Aboriginal constituencies will be changing. A fifth obstacle, a failure of the Canadian government to deliver a national children's action plan, which responds to a number of child-sensitive governance and other recommendations contained in the last set of concluding observations directed to Canada by the expert UN Committee on the Rights of the Child in December of 2012. So there's been 3 sets of concluding observations issued by the Monitoring Committee, the UN Committee on the Rights of the Child to Canada, in 1995, in 2003, and the last set in December of 2012. So then the last area, is what are some of the steps that we can take in Canada to improve the current state of Canada's children and fulfill the original vision of the Convention? The first is to establish an independent National Commissioner for Children and Youth. We're very fortunate in this province to have somebody like Bob Pringle, to have the independent office of the Child and Youth Advocate, but we need to have somebody sitting in Ottawa to provide some oversight and to assume the same kind of mantle with respect to federal jurisdiction. Since the 1990s, independent human rights institutions for children have emerged globally as influential bodies, promoting children in public decision-making and discourse. There are now 200 of these offices at work in over 70 countries. Most industrialized nations have established such independent human rights institutions for children and youth, including federal states like Canada. For example, England, Scotland, Ireland, Northern Ireland, Wales, New Zealand, Australia, and Sweden have all found such offices to be highly effective. Parliament should therefore establish and appoint, through an impartial selection process, an independent National Commissioner for Children and Youth. This position would help to ensure that the rights of Canadian children are more uniformly protected from coast to coast, and that fewer children are excluded from services and opportunities. It would also be instrumental in monitoring implementation of the Convention, in investigating systemic complaints, in making annual reports to Canadians on the status of children and their rights, and in facilitating participation by children at the national level in terms of setting a national agenda and keeping us all accountable to uphold that agenda. A National Commissioner's Office would also be able to address matters outside of the jurisdiction of provincial and territorial child and youth advocates. So that would include areas such as immigration, social security, tax benefits, youth criminal justice, on-reserve services to First Nations children, and divorce law. Second area, second action step, carry out law reform and incorporate the Convention into domestic Canadian law. So Parliament should also pass enabling legislation to make child rights a part of Canadian law, and to ensure that all legislation in Canada complies with the Convention on the Rights of the Child and other international normative standards for children. Due to Canada's dualist constitutional structure, although Canada has assumed binding international obligations, so we're talking about a convention and not a declaration, so by ratifying the Convention on the Rights of the Child, nevertheless, the Convention doesn't have automatic effect in Canada because it hasn't yet been fully incorporated into our domestic law. However, even without passing enabling legislation to make the Convention part of Canadian law, which many other countries have done globally, Canada can do more by requiring a more consistent and coordinated approach to law reform, in conjunction with the structured use of child rights impact assessments. Rather than taking a piecemeal approach to reviewing legislation, which can lead to the unequal and discriminatory treatment of children according to province or territory or different service sectors even within the same province. What is required is a more uniform approach to legislating and enforcing children's rights in accordance with normative standards for children set out in the Convention. So to take the example of our various child protection statutes across this country, it's worth noting that there are different maximum ages for child protection intervention, ranging anywhere from 16 to age 19. Different formulations of child protection grounds in different child protection statutes, different codifications of specified rights for children in state care, and different levels of child participation and entitlement to legal representation both within and outside of the court process. So in this context, it's hard to justify a sliding scale of child rights entitlements based purely on geography or differential age thresholds. That shouldn't be happening. Thirdly, implement a process of child rights impact assessments at all government levels. So all levels of government should develop a framework for child rights impact assessments on legislative and policy proposals that could have significant impacts on children. So what is a child rights impact assessment? Well, it's a tool for assessing and reviewing the potential impacts of a proposed or existing policy, law, program, or particular decision on children and their rights. And as part of that process, the convention is the framework used to assess these impacts. There are different tools and templates that have been developed in different jurisdictions. And the impacts that are revealed through this process can be positive or negative. They can be unintended or intended, direct or indirect, short-term or long-term. The focus is to understand how the matter under assessment will contribute to or undermine fulfillment of children's rights and well-being, and to be able to maximize positive impacts and avoid or mitigate negative impacts. It builds upon evidence-based research. It takes into account the voices and perspectives of young people, and it doesn't treat children as one homogeneous group. And it recognizes that different groups of children can be treated differently, and we need to kind of look at equitable outcomes. And one size doesn't fit all, and we could be doing some serious harm unintentionally. So how do we accommodate the needs and interests and rights of different groups of children? Internationally, there are a growing number of countries using child rights impact assessment processes, including Flanders and Belgium, Finland, Sweden, Scotland, Northern Ireland, Wales, England, Australia, and New Zealand. Impact assessments are not a new phenomenon, and there are now various forms, such as gender, privacy, health, and environmental impact assessments. So why shouldn't the well-being and rights of our children be given at least the same priority and scrutiny as these other areas or subject matter? To date, there's been no commitment to apply a child rights impact assessment framework at the federal level. And any attempts to determine if the Convention on the Rights of the Child and other international human rights instruments have been fully considered in the development of federal bills have failed. This was certainly the case in my experience when examining the proposed amendments to the Youth Criminal Justice Act a few years ago, which seemed to place more emphasis on deterrence and less on reintegration and rehabilitation principles. And it was certainly, in our estimation, a violation of charter rights, of convention rights, and when we tried to probe how did this reach the state of a bill, and should the parliamentary committee consider that particular bill and the human rights instruments, it was very difficult to probe into that, to determine to what extent that had been properly considered. We need to see more of that. Two more areas before I close. Ratifying the third optional protocol to the Convention on the Rights of the Child. So the third optional protocol to the Convention on the Rights of the Child establishes what's called a communications or complaints procedure by which an individual child, group of children, or their representatives from any country that is a party to the optional protocol can bring complaints directly to the UN Committee on the Rights of the Child in Geneva. This procedure can be used where children allege violations of their rights under the Convention or the other two optional protocols. After they have first exhausted domestic legal remedies, or where the application of the remedies is unreasonably prolonged, or where the application of those remedies are unlikely to bring effective relief. The optional protocol also allows the committee to open an investigation of what's called grave or systemic violations of children's rights by a state party upon receipt of reliable information. So the third optional protocol came into effect on April the 1st, 2014. And there are currently 50 signatories and 26 nations that have ratified this protocol. But Canada has done neither as of this date. This protocol, if ratified by Canada, would establish a complaints procedure under the Convention on the Rights of the Child that is similar to those previously established for most other core human rights treaties, and would go a considerable distance in transforming the paper rights of the Convention into lived rights for children under 18 years of age in this country. And it certainly would give another dimension to the role of provincial child and youth advocates in terms of examining some of these rights violations. There has been some speculation previously that the resistance on the part of Canada has been to frustrate systemic inquiries that could be convened in relation to the violations of Indigenous rights in this country. So hopefully with the change in government, we may get another approach and some movement in terms of ratifying this third optional protocol. The last action step is to ensure the equitable treatment of our Indigenous children. And I know this really resonates here in this province. It certainly resonates in this city. The work that's been done here at the College of Law in terms of establishing an Aboriginal Law Centre is certainly very laudatory. So the equitable treatment of Indigenous children should be identified as a top national priority, with transparent analysis of evidence that suggests discrimination, coupled with regular annual reporting on progress made in legislation, program funding, and outcomes. So in the last set of concluding observations to Canada, in December of 2012, the UN Committee on the Rights of the Child called upon Canada, and I'm quoting, to take urgent measures to address the overrepresentation of Aboriginal and African Canadian children in the criminal justice system and out-of-home care. And then they continued, again I'm quoting, Canada should take immediate steps to ensure that in law and practice Aboriginal children have full access to all government services and receive resources without discrimination. More recently, as again we heard a little bit earlier, the Canadian Human Rights Tribunal has adjudicated a human rights complaint brought jointly by the First Nations Child and Family Caring Society and the Assembly of First Nations 9 years ago, and found discrimination under the Canadian Human Rights Act in the funding and provision of child welfare services to Aboriginal children residing on reserve. In its recent decision, the tribunal ordered Aboriginal Affairs and Northern Development Canada to cease its discriminatory practices and reform the First Nations Child and Family Services Program, and further, to take measures to immediately implement the full meaning and scope of Jordan's Principle. So the tribunal's decision is not limited to child welfare services and should serve as a catalyst to end discrimination on all levels, including guaranteeing the right of Canada's Aboriginal children to an equitable standard of health, education, housing, and clean water. Moving from this point forward as a nation, we need to continue this journey towards reconciliation and ensure that Indigenous children are as healthy, well-educated, and supported in their communities as all other children. Ultimately, the fair and equitable treatment of Aboriginal citizens and their children is everyone's responsibility, and not just that of government. So again, as we've heard, reconciliation is really an obligation for all of Canadian society. It doesn't just fall to Aboriginal communities and Aboriginal leadership. So to conclude, as we get ready to mark the 25th anniversary of Canada's ratification of the Convention on the Rights of the Child later this year, it's critically important that we do more than engage in lofty rhetoric and simply take account of our successes and failures and pat ourselves on the back. In order to fulfill the true promise of the Convention, we must continue to work towards full implementation of the Convention in this country. We must find creative and transformational ways to work together in partnerships. We cannot afford to continue at the same pace for the next 25 years, aside from the fact that many of us are getting older. Not when we know that children in this country are stuck in the middle, and that there's been no improvement in their well-being in over a decade. Unless efforts are stepped up, the rights of too many of our children here in Canada will continue to be abrogated or go unnoticed. The time has come to act with passion and a sense of urgency in raising the bar on children's rights and child well-being in this country. And this was the message that came across to us in Geneva in September of 2012 when the Canadian delegation reported to the UN Committee on the Rights of the Child. The strong message from the committee is Canada needs to do more to raise the bar on children's rights. Having painted a somewhat bleak picture for the children and youth of Canada when it comes to assessing their well-being and the enforcement of their rights, it's only fair to acknowledge the positive change in tone and promising early statements emanating from our new federal government. This has been evident in the announcement of the cabinet appointment for the first time of a federal minister of families, children, and social development, as well as the Prime Minister appointing himself as the Minister for Youth. It has also been reflected in the government's commitment to implement all 94 calls to action in the Truth and Reconciliation Commission report. Nonetheless, we must not become complacent, and it's up to each of us to do our part and remain strong and committed child rights advocates, especially as we approach the quarter-century anniversary of Canada's ratification of the Convention. So we can't wait for others to take the lead. This is really a collective responsibility that all of us should be upholding. So thank you. I'm going to stop there, and is there time for one or two questions, or afterwards? Turn it over to my colleague. Thank you.
Good morning, everybody. I'm representing CUSO International. It's a Canadian organization that's been going for some 50-odd years. Their goal is to recruit and send volunteers all over the world. I think last year, I may be wrong on this, but I have a feeling they sent over 2,500 volunteers to various countries across the world. They've just recently started sending volunteers in Canada. And a friend of ours that we met in Guyana is a volunteer to a First Nations organization located in Alert Bay, which I had to look up. This isn't Alert Bay way up north. This is Alert Bay that's off the northern end of Vancouver Island. And we hope to visit him later this year. Coincidentally, today, well, not just today, it's very close to a year when we returned from Myanmar. My wife and I were volunteers there for 4.5 months. I was working with an organization called Equality Myanmar. My project there was to research, draft, and edit a joint submission to the 2015 working group of the Human Rights Council on behalf of a coalition of some 30-odd civil society organizations, almost all of whom were located in Myanmar. I think there were one or two that were based in Chiang Mai in Thailand. This joint submission is part of a program instituted by the UN's Human Rights Council entitled the Universal Periodic Review, or UPR, whereby every member of the UN is reviewed every 4 years from a human rights perspective. You may recall that in 2013, Canada was reviewed, and there were some negative comments that were made, particularly with respect to our First Nations people, which the two previous speakers have already mentioned. 2015, it was Myanmar's turn to be reviewed. They'd been reviewed in 2011, and 2015 was a key year for Myanmar in many respects, because it was slowly, very slowly, evolving to a democratic society from a military dictatorship. Before getting into sort of some specifics of human rights in Myanmar, I thought it useful just to give you a bit of background about Myanmar. I have to indicate to you that I knew very little about it before I went. For some 50 years, Myanmar has been under the complete control of a military dictatorship, following a coup d'etat in 1962 led by the army. The first significant challenge to this dictatorship occurred in 1988, when the students at the University of Yangon protested en masse. Needless to say, this protest was brutally repressed by the military junta, with many results. A number of students were killed, a lot were imprisoned, and many fled to other countries, particularly Thailand. The university was completely shut down by the military. It's a huge campus in the middle of Yangon with all sorts of lovely buildings, and it just was shut down cold. They did establish 4 sort of sub-universities in communities in the hinterland of Myanmar, well away from Yangon. As a matter of interest, my executive director was one of those students in 1988 who protested and fled to Chiang Mai, where he stayed until, I think, about 2011. At that point, he still had friends in the military, friends that he went to university with, and he applied to get consent to return to Myanmar, where he set up Equality Myanmar. In the next sort of stage is in 1990, there was an election in Myanmar, which was won by the National League for Democracy and the Shan Nationalities League for Democracy. The results of this election were completely ignored by the junta. They went on governing the way they did, and just as if the election hadn't taken place. The National League for Democracy, or the NLD, was a party that was led by Aung San Suu Kyi, also known as the Ladies. In 2008, Cyclone Nargis struck the mainland of Myanmar, leaving some 140,000 people dead and affecting 3.4 million people, the worst natural disaster to ever hit Myanmar. The result of the junta was just terrible, disastrous. It was slow to react. It refused to allow foreign aid organizations entry into Myanmar. What relief and supplies were landed, the military took over for their own use. They used forced labor to do projects that the military wanted done, and ignoring some of the rebuilding structuring that needed to take place. At the same time, the military pushed ahead and passed a new constitution, which is in force today. It's interesting to note that Chapter 8 of this 2008 Constitution deals with fundamental rights and principles, which are approximately equivalent to the rights given by the Constitution of other countries. However, notwithstanding it's in the Constitution, very little action has been taken by the government to date in trying to enact local laws to carry out these principles. As many of you know, there was an election in November of last year, a very exciting one, whereby the NLD, the party of Suu Kyi, won an overwhelming majority in both levels of the parliament, both the upper and lower assemblies. Both the president, who happened to be an ex-general person, and the senior general of the army have publicly agreed to recognize the results. They've met with Suu Kyi, and the NLD is on track to assume responsibility for governing Myanmar next month. Let me turn to the human rights status in Myanmar. As I indicated, the first review done by the Human Rights Council working group was in 2011. There were some 281 recommendations that were made by the various countries that were members of the working group. 124 recommendations were supported by Myanmar. 88 recommendations were deferred for further reply by Myanmar, and 69 recommendations were not supported by Myanmar. When I first got to Myanmar and was given this project, I had to do a great deal of work. One of the biggest problems I faced is that very few people in Myanmar spoke English, and my knowledge of Burmese was extremely limited, in fact, non-existent. So the research, I thought I'd be able to meet with a number of these organizations that were part of the coalition and get their input about the particular areas they were interested in. Not so. So I had to get back to the books, which I hadn't done for quite a while. My initial review sort of outlined 18 major human rights issues. And I got this from reading the local newspapers that were written in English, and the many articles, journals, periodicals, and reports written by many of the international organizations that deal with human rights. This proved to be a problem. The submission, the joint submission of the coalition, was limited by the guidelines of the working group to 10 pages or 5,262 words. The word count came in later, I think, because people said, okay, it can only be 10 pages. And I think they used a font about the size of number 4, which you could hardly read, but they got a lot more in it. So this year they came up with a word count, which was interesting. You can't say a lot in 10 pages. So the biggest challenge I faced at that time was to take the 18 issues, go to my executive director and say, you know, Mew, we can't talk about 18 issues. They're all important. They all affect Burma or Myanmar. We need to slim this down. I suggest we pick 5 topics that are probably most important in the view of the members of the organization or of the coalition and go from there. We ended up with 9, which wasn't a bad compromise, I guess. The day before I left, we had a meeting with the members of the coalition. I think 19 of the 28 or 30 members were there with representatives, and I sort of started off with a translator, needless to say, saying, listen, we're 600 words over the limit. We need to slim down. What can I take out? What can I delete? Well, the rest of the day, they'd ignored what I said. The rest of the day were comments about, why didn't you talk about this? Why didn't you talk about that? Did you know about the case of this? And I said, listen, I agree with you, it's an important issue, but what do we take out instead? I have to get smaller, not larger. Anyways, I left the next day, and my executive director and the executive director of an organization in Chiang Mai agreed to do the editing, and the joint submission finally got done and got submitted. Let me turn to, I guess, 4 areas, human rights areas in Myanmar. The first one is the civil and political rights. As you know, there are essentially 3 freedoms: freedom of expression, freedom of assembly, and freedom of association. There's little doubt that there's been some improvement since 2010. With some limitations, newspapers have been allowed to publish articles criticizing government policy. This was unheard of prior to 2010. However, notwithstanding the introduction of new legislation, both the new legislation and old legislation, some of which goes back to the 19th century, if you can believe, are still being used to stifle the CPR rights. Let me give you a couple of examples under this topic. In 2011, the government enacted the 2011 Peaceful Assembly and Peaceful Procession Act. Sounds great. It seems to allow peaceful demonstrations, which were not allowed before. But to hold a peaceful assembly, you needed to apply for consent with complete details as to time, place, slogans, purpose, as well as the name and addresses of the organizer. Very difficult to obtain. Very few consents were granted by the government. In addition, the Act went on to provide that a contravention of any provision of the Act made people criminally liable. And in fact, people were charged under this Act, which supposedly was supposed to be a step forward, but in some respects turned out to be a step back, particularly for those that were incarcerated. The second case, example, deals with Cotter. He was a freelance journalist who was taken into custody by the military in 2014, tortured and murdered. The military claimed that he was a spy. He was working for one of the ethnic armed organizations working in, I think it was Mon State, which is down in the southern part of Myanmar, and he was shot trying to escape. His body was not delivered to his family, was buried, and the military hoped forgotten. He wasn't. There was a huge outcry from human rights defenders, both nationally, within Myanmar, and internationally. The end result is they exhumed his body and looked at it, and it was found that signs of torture, a number of bullet holes in him, and this just sort of put more fuel in the fire. The United States has publicly called for a detailed examination of the case. When I was in Yangon, I had an opportunity of meeting with Cotter's wife. She was an incredible person. I guess she was probably in her late 30s, early 40s, and she took upon herself to say, this isn't right, I want to sue the military and the government. She was faced with an almost insurmountable task. One, trying to learn all the regulations, procedures, law, and legislations that were applicable, and they were many and varied. And it wasn't easy to find some of these rules and regulations. They don't have a central library the way we have, and sometimes you really have to go looking for them. Just recently, the district prosecutor who was assigned to this case and who'd been working on it since she started her action was transferred to another jurisdiction without notice. Just the next day he was gone. All the history he'd built up in this case disappeared. And all this did was to allow further uncertainty and delay to this case. Another example is in 2015, the government introduced a new Education Act, or bill at that stage. The students and teachers protested against this bill, with the result of a number of them were charged under the various provisions of that so-called 2011 Peaceful Assembly and Peaceful Procession Act, as well as two 19th century statutes, the 1861 Police Act, the 1890 Rangoon Police Act. Unbelievable. But these were acts on the books of the country. I actually read part of the Rangoon Police Act in connection with an LBGT claim that I knew something about. The sections were very short, very vague, very general, and could be interpreted almost any way you wanted. Needless to say, the judiciary, and this will become a little more relevant later, interpreted them in a very favorable light of the government. So these acts were still enforced and still being utilized. Second area is economic, social, and cultural rights. Since 2011, Myanmar's economy has gone through major changes as it seeks to liberalize its economy and attract foreign attention. Unfortunately, Many of these changes have resulted in significant human rights issues. Land confiscation, with little or no compensation in order to support 3 economic zones that have been blocked off by the government for foreign investment. Forestry and mining issues or initiatives, again supported by international organizations, have given rise to this question of expropriation of land without compensation or minimal compensation. Secondly, forced labor by the military and other government organizations, particularly in the garment industry. Thirdly, exploitation of natural resources, again by international bodies. These changes have resulted in little or no benefit to local communities. Many of the communities in Myanmar are in a state of poverty and have a lack of food. The Asian Development Bank has estimated that about 25% of the population lives below the poverty line. Obviously, this is much, much higher in the rural areas. The government has taken some steps, again, is feeling the heat from the international organizations. They passed the Rural Development and Poverty Reduction Plan, which, great names, some of these new statutes coming in, which proposed to reduce poverty by 16% by 2015. It's too soon to know whether this lofty goal has been reached. I think it's highly unlikely, but it's on the books. Another area involves religious discrimination. Some of you probably may know of that, may have read about it. In Myanmar, particularly against the Muslims, many of whom are located in Rakhine State. Rakhine State is in the northwest of Myanmar. The international press has been very active in this field. They've written many reports and articles criticizing the actions and lack of action of government in this area. There are a couple of examples of this discrimination. Many of the Muslims living in Rakhine State have been denied citizenship, even though their families have lived in the area for many, many years, in fact, centuries. The Rohingya Muslims, who are now living in Rakhine State, apparently migrated over from neighboring India about 400 years ago, and their descendants still haven't been able to get citizenship. Myanmar, in case some of you don't know, is essentially a Buddhist state, with I think 95% of the people there are Buddhist. In another example of this discrimination, when I was there, they presented a bill, which is now, I have learned, being passed, entitled the Interfaith Marriage Act, which imposes restrictions on a non-Buddhist man marrying a Buddhist woman. The non-Buddhist man must register his intent to marry a Buddhist woman. There's public notice. Anyone could object. There's a hearing before a local official with very uncertain results. Most importantly, the Act states that Buddhist law must apply to all family law issues. Let me turn to administration of justice. I guess I'm all right from a time perspective, am I? I sort of lose track. 3 major areas in the administration of justice. Quite obviously, this is something that was very near and dear to my heart. The 2008 Constitution established the Supreme Court as the highest court in Myanmar, with jurisdiction over all matters except constitutional matters, which there was a separate court, and military matters, and there was another court for that too. The Chief Justice of the Supreme Court was nominated by the President. Keep in mind, an ex-military, an ex-army man, general, with the approval of Parliament. However, under the Constitution, Parliament must approve the nominee unless that nominee failed to meet some of the basic qualifications set out in the Constitution. Subsequent to this appointment, the President and the Chief Justice then selected the remaining Justice of the Supreme Court. Similar procedures occurred with respect to the high courts and the lower courts. It's evident that the judiciary is under the indirect control of the government and the military. This state of affairs has been noted by several of the special rapporteurs appointed by the Human Rights Council, and many recommendations have been made for change to the Constitution, but nothing's been done to date. The second issue involving administration of justice relates to significant bribery and corruption in the judicial system. It is common knowledge that one must pass cash to the appropriate court official to ensure that you get a favorable decision. In 2013, a case came to the public's attention involving a judge's wife who requested $150,000 US from a party in order to ensure a favorable judgment from her husband. Needs to say, the judge was dismissed and she was charged, and I don't know whether she had a jail sentence or not. The important thing is the bribery and corruption that's inherent in the judicial system came to the public's attention, which attracted a huge public outcry. The third issue relates to the situation where there's no independent bar association, with the result that there's no strong independent national bar organization to challenge the government where necessary. There is a Myanmar bar council. It has 11 members, 6 of whom were selected by the Supreme Court, and 5 of whom are government officials. And to your great surprise, the chair of the council is the Attorney General. You can see how independent that organization is. The last area I wanted to talk about in this area of human rights, keep in mind I'm going from 9 to 4, so I guess the time frame that's imposed on me. Women and children. It's important to note that Section 21 of the 2008 Constitution provides in part that every citizen shall enjoy the right of equality. As well, Myanmar has ratified the Convention against Elimination of All Forms of Violence Against Women in 1997. Various local and international civil society organizations, including the Human Rights Council, have pointed out that many of the provisions of CEDAW, this convention, have not been carried out or introduced in Myanmar law. There are many reports in local newspapers of violence against women, particularly in the areas of conflict around the borders of Myanmar. There are also some reports, and this was something that just blew me away, but I guess it's a fact of life in a third world country. There are also reports of young women in the rural areas being sold by their families so they could earn hard cash in the urban areas. Many of these young women found their way to cheap hard labor in factories, in the sex trade, and as workers in family homes. There is a general lack of awareness of the rights of women at the government level, at the legislative level, and at the local level in Myanmar. There's a tremendous need to strengthen the legal system so that women have access to justice. That's why the widow of Koji is so impressive. It was unheard of that a woman would take the time and trouble to educate herself into the legal procedures and bring a case against the military. Children are facing many of the same issues as women. Although education is officially compulsory until the age of 16, not 18, in fact, less than half of Myanmar's children receive the education at this level. Children are used as child labor in tea shops in Yangon, which were frequently served by boys, somewhere between 9 and 13, both during the day and night. They just didn't go to school. They worked, they earned cash. Child soldiers, major problem. both the military and the ethnic armed organizations with the ongoing struggles that are taking place in Myanmar now. The government has, in fact, taken some steps in this regard by signing the optional protocol to the Convention of the Rights of the Child involving children in armed conflict in 2015. 2015, just last year. In fact, some child soldiers have been released. When we were there, the military made a big fuss about 47 child soldiers being released and had pictures taken of them. Just 47. And I don't know what the size of the military is, but it was just a mere scratch of what, on the surface of what needed to be done. This also didn't address the child soldiers that were enlisted, if I can use that expression, by the ethnic armed organizations that were fighting against the military. Child trafficking, another major issue, particularly involving children going to Thailand, again for cheap labor and in the sex trade. The government, in this regard, is working with the government of Thailand and other international authorities to try and take steps to alleviate this problem. Let me sort of try and pull some thoughts together in my summary. There's no doubt that Myanmar has taken some strides in improving its human rights record over the last 5 years. But it's interesting to note that of the 9 core human rights instruments, the Myanmar government has only adopted 3 of them. The Convention on the Elimination of All Forms of Discrimination against Women in 1997, which I mentioned, the Convention on the Rights of the Child in 91, and the Convention on the Rights of Persons with Disabilities in 2011. That's it, 3 out of the 9. And many organizations, including the UN Human Rights Council, the special rapporteurs or investigators that are appointed by the Human Rights Council, have strongly recommended this being done, and there's little or no action in this regard. As well, and this is sort of, I think, a key point, notwithstanding the ratification of these 3 conventions, there's been little movement on behalf of the government to repeal or amend local laws to bring them into conformity with these international conventions. The working group has recommended, and this has been endorsed by the council itself, that Myanmar proceed to pass or sign and ratify these other 6 conventions. Let's hope that the new government, led by Aung San Suu Kyi, will do much better in this regard. Thanks for your attention.
Thank you very much. We have time for 1 question or 2 if... Okay, go ahead.
Marvin, thank you very much for your careful look at the plight of children's rights in this strange country of ours with its dualist and federalist challenges. I have an action step that I'd like you to consider on adding to your list, and that is that there's a vehicle that could be resurrected that might be very helpful, and that is a vehicle of federal, provincial, ministerial consultation, periodic consultation on human rights. Such an organization did exist, and it last met in 1988. It would be a very useful thing, I think, right now for the federal government to invite the provinces once again to sit at that table and address, amongst other things, the urgent need to deal with the checkerboard with regard to children's rights in this country. I wonder if you want to comment on that.
I think that's a very constructive suggestion. I think what has happened over the past number of years is that there has been a lack of coordination around children's issues between the federal and provincial governments. For example, there's a network of directors of child welfare, and they meet, they come together periodically, and some years ago this used to be supported at the federal level. There was a secretariat trying to work through in a collaborative way plans and issues and activities that would benefit children. And a number of years ago, the federal government pulled out and said child welfare is a provincial responsibility. We don't need to be at the table. So that has created problems, a lack of consensus, a lack of standardization of approaches that are going to reinforce the rights of children. So I think that there has been this kind of siloing out, this fragmentation that has really been hurtful to children. And I think to the extent of which we can have the federal government working together with provinces and territories, trying to come together with a common set of purpose, we really have to pull together and find a way to improve the life conditions for children. And I think that's an excellent example. So thank you very much.
Good morning. Thank you both for your presentations. I want to add something to what Professor Norman just said. We need to talk to the mums and the grandmas. We need to talk to the families. We need to include Indigenous people in leadership in this. Talking about Indigenous children issues in this country through government mechanisms hasn't worked. It hasn't worked, and it's worse than that. It's been more than disastrous. And so we have to stop doing it from this top-down approach, looking in, seeing what is wrong inside there, and going inside the community, because the mums and the grandmas actually have the capacity not only to determine what should be happening, but to participate in that. And so I think the mechanism needs to be a little bit bigger than just a federal, provincial, territorial mechanism. Thank you.
I would certainly endorse that. I think we need to engage communities. And I recall, I'm sure Bob has had this experience, when I used to travel the province and I would go out to First Nations or Métis communities, I wasn't coming with a lot of preconceived ideas and notions. I was trying to reach out and kind of draw upon the community's knowledge and frame of reference in terms of what did they think their own concerns were, and what were some of the suggestions and solutions that they thought they'd figure out for themselves, and then how could offices such as the Child and Youth Advocate support some of those solutions and some of those very constructive approaches. And we need to be careful that we don't somehow come forward with a sense of judgment that we have figured this out. We don't live in those communities. We have to understand that the people who experience the services on the ground have a much better perspective as to what could really make things better. So thank you for that observation.
We'll take one more quick one, and then we'll break and come back for 11 o'clock.
Thank you. I just want to follow up on the previous question. I listened to Justice Sinclair last night in Regina, and he described the social services system, particularly as it relates to children in Canada, as fundamentally genocide, and that system is fundamentally flawed and should not be sanctioned, relied upon, or looked at. And in fact, suggested that the definition of family, which we, as our binary society defines it, is inherently genocidal when it comes to the destruction of a culture which doesn't see the family as binary, which includes grandmothers and aunts and uncles and all of those other categories. Our social service system doesn't recognize that. And the second thing, this didn't come from Justice Sinclair, but Caleb Ben and others now, medicine has recognized that the trauma that children who are the victims of the genocide in this country, residential schools, past system, 60 scoop, the trauma is passed on genetically. And no matter how much benevolence we want to provide through social counseling, it's going to take generations of a different life experience, grounded in original hereditary culture, potentially 6 generations before the genetic trauma is healed. And so I'm wondering, in your view, I like to ask for free legal advice when I can. Do you think it's possible to use the Charter, Section 15, to suggest that we need to develop that kind of system because the present one is racist and discriminates on the basis of cultural values and family definitions?
Well, it's interesting that if you read through the decision of the tribunal, the Canadian Human Rights Tribunal, they draw upon, in finding discrimination under the Canadian Human Rights Act, they draw upon the Charter, not only Section 15 of the Charter, but also on several articles of the Convention on the Rights of the Child, several articles of the UN Declaration on the Rights of Indigenous Peoples, other international human rights instruments. And so these documents can be used in concert. And the Supreme Court of Canada has said that when interpreting the Charter, courts should be looking at international human rights instruments and taking the principles of those international human rights instruments at their highest level, at their apex. So I think that there is a lot of room for advocacy and Canadian jurisprudence drawing upon human rights advocacy in conjunction with the Charter. One of the points made by Justice Sinclair, too, is we have 94 calls to action. Those are a lot of calls to action and recommendations. But if people can pick one or two that you're really passionate about, that you have a significant investment in, where you think that you can make a difference, grab on to those 1 or 2 calls to action. And together, there can be ripples, and we can make a real difference. I just want to make a bit of an announcement in terms of, in my spare time, I serve as the chairperson of the National Children's Law Committee of the Canadian Bar Association, and we are developing a digital toolkit on children's rights, children's human rights, and we expect that this is going to be available to judges, lawyers, law students, and policymakers probably within the next 6 months. And we have a number of people, lawyers and others, that we're drawing upon who have taken over certain thematic areas. And we're developing practice tips, identifying pivotal case law, what are some of the practical considerations that lawyers who practice in these various areas should be considering. My last announcement is that through the Canadian Bar Association, the Children's Law Committee, we are convening a webinar on St. Patrick's Day, March 17th, just happens to be. And the webinar, which your time would be from 11 to 12:30, is going to be on the implications of the tribunal decision. And we have lined up Cindy Blackstock, who has been the real driver, the real catalyst, the real champion behind the human rights complaint. Sarah Clark, one of the lawyers for the First Nations Child and Family Caring Society, and Sarah Rauch, who is a member of our National Aboriginal Law section. So we can certainly transmit that flyer, and I would encourage you to try and find an opportunity to view the webinar. I think all of us are trying to assess what are the implications, what can we be encouraging and supporting as we go forward. So thank you for giving me that opportunity to make those plugs. So thanks very much.
Thank you. That'll conclude